back to Winning Isn't Easy. Let's talk about the Sergeant Schultz defense and what one claimant argued to a judge about the fact that they didn't know they had to appeal and exhaust their administrative remedies before filing a lawsuit. Now, I am sure that you understand that one of the hallmark features of the ERISA law is that if you're going to file a claim for disability benefits and it's denied or terminated, you have to file an appeal. That's called an exhaustion of administrative remedies. And most denial letters will make it fairly clear that you have to exhaust the administrative remedies before filing a lawsuit. There are a few exceptions, but they didn't apply in this case. So do you remember Sergeant Schultz character in the TV series Hogan's Heroes? I love that Sergeant Schultz defense. In the recent case of Constantini versus Hartford Life, this case out of New York, Ms. Constantini became disabled in January of 2018. She filed a long-term disability claim. It was denied. She got a denial letter, and it didn't necessarily state that filing an appeal had to be done before she could file a lawsuit, but it was clear that action had to be taken. She argued that she was unaware of the requirement to file an appeal, and she admitted that she didn't file an appeal before she filed a lawsuit. That is the kiss of death. The denial letter did say that, in quotes, should the claim decision be upheld on appeal, you will then have the right to bring a civil action under Section 502 of the ERISA statute. And the court didn't buy that this I know nothing at all argument that she made. And the court granted Hartford's motion to dismiss the lawsuit for failure to exhaust the administrative remedies. Obviously, the time in which to file an appeal had long passed, and as much as you would like to get to court as soon as possible, you under the ERISA statute have to exhaust the appeal process. The ERISA law generally gives you up to 180 days in which to file an appeal, and the appeal is the trial of your case. If you don't file the appeal and try to go into federal court, the judge is going to say you haven't exhausted your administrative remedy. Now, remember, once the appeal process is completed, there's no evidence that can be added to the file, and there's no trial. And cases are decided on a motion for summary judgment. So if for some reason you were to get past the argument that you didn't exhaust your administrative remedies, the judge is only going to see what was in the carrier file. And generally, that's not going to be in your favor. What Corelli should have done when she got the denial letter was to hire an experienced ERISA disability attorney who would explain to her, we've got 180 days in which to file an appeal. We need to get the carrier's file. We need to develop the medical and vocational evidence that will establish that you meet the definition of disability. And I'm going to write a appeal letter, 25 to 65 pages long, that will go through the facts, both medically and legally, make legal arguments as to why that denial was wrong, timely file that appeal. And then if the appeal is denied, file a lawsuit. That's exhaustion of administrative remedies. So you need to remember that the Sergeant Schultz defense is not going to work in an ERISA disability claim. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you have liked this episode, I would ask that you please share it with your family or friends. Please subscribe. Please like it, because this is an educational podcast for those who are involved in ERISA disability claims. I want you to understand the disability carrier's games, the rights that you have, and what you need to do to protect yourself. So I look forward to talking with you in our next podcast. Thanks.